All right, let's dive right into a huge question, one that basically defines the digital world we live in. Who gets to own an idea? And maybe more importantly, if you share that idea online, are you actually stealing? It's a complicated question, so let's unpack it.
You know, back in the early 2000s, this quote pretty much nailed the mindset of the entire music industry. A war was brewing. But this wasn't a war with cannons and ships. It was a war between massive record labels and millions of ordinary people, a lot of them college students, probably just like you.
And the battleground? It was these peer-to-peer file sharing programs, like Kazaa and Napster. At their peak, we're talking over 60 million music fans using these things to download and share songs. To the industry, they were all pirates, but to the people using them, as you can see from this ad, they were just fans sharing the music they loved.
Now, to prove they weren't kidding around, the record label started suing individuals, and the penalties were just insane. Look at this number, $675,000. That is how much a Boston University grad student was initially ordered to pay for sharing just 30 songs online. I mean, do the math, that's more than 22 grand per song.
So what was really going on here? Was this all just about money, or was it something way deeper? To really get to the bottom of this conflict, and trust me, it's still super relevant today with things like streaming and AI, we have to wrap our heads around this very strange, very powerful, and honestly pretty confusing concept: intellectual property.
So before we get any further, let's just back up and ask a really basic question. Can you actually own an idea in the same way you own, say, a car or a laptop?
Okay, so what is intellectual property? Well, the textbook definition is any unique product of your mind that has some kind of commercial value. The basic argument behind it is pretty simple. If you put your labor into something, you should own the result, right? If you chop down a tree, you own the firewood. So by that same logic, if you put in the labor of writing a song or coding an app, you should own that creation.
But here's where it gets tricky. Ideas are just different from physical things like firewood, which leads to this really interesting paradox. Imagine two famous playwrights living at the same time, like Shakespeare and Ben Jonson. What if they both hear the same juicy piece of gossip, get the same exact idea for a play, and write the exact same script completely independently? So, who owns it?
And this little comparison just perfectly illustrates the core weirdness of it all. Think about it. If I steal your car, you don't have a car anymore. It's gone. But if I steal your joke, you still have the joke. We can both tell it. The idea wasn't removed, it was just copied. And that one key difference is what makes protecting ideas so incredibly complicated.
So, how in the world do we manage this weirdness? Well, over time, governments came up with 4 main legal tools to try and protect different kinds of ideas. First up, you've got the trade secret. This one's pretty straightforward. You protect your idea by keeping it a secret. The most famous example, of course, is the secret formula for Coca-Cola. It's never been patented, it's just locked away in a vault. And as long as that secret stays secret, the protection basically lasts forever.
Next, we have trademarks. Think of these as brand names or logos. You can see in this old Xerox ad, they're explaining why the name itself is so important. A trademark is a word or a symbol, like Kleenex or Band-Aid, that lets you know exactly who made a product. And this is why companies get so protective when people start using their brand name as a generic word for all tissues or all bandages.
Then there are patents, and these are for inventions. A patent is basically a bargain with society. An inventor gets a temporary monopoly, usually about 20 years, to be the only one who can make and sell their invention. But in exchange, they have to publicly reveal exactly how it works, so that once those 20 years are up, anyone is free to build it.
And finally, we get to the big one for our story, copyright. This is all about creative works. We're talking music, movies, books, even software code. Copyright gives the creator a whole bundle of exclusive rights, like the right to make copies, to distribute them, and to perform the work. And this is the legal weapon the music industry used to go after file sharers. But just look at how much copyright has changed. Back in 1790, it lasted for 28 years, max. Today, for a work owned by a corporation, it can be over 95 years. Critics have a name for this: copyright creep. They argue that these terms have stretched way beyond their original purpose, often to keep iconic characters like Mickey Mouse from ever becoming public property.
Okay, so with these incredibly long and powerful protections in place, is it ever okay to copy something without permission? I mean, can a professor show a movie clip in a lecture? Can you quote a few sentences from a book in a paper you're writing?
Well, the answer is sometimes. And the reason why is because of a really crucial and important exception that's built right into copyright law. It's a concept called fair use.
Now, fair use isn't some simple checklist. To figure out if copying something is fair, courts have to balance these 4 factors. Like, are you using it for a school project or to make money? Are you copying a whole movie or just a 10-second clip? And maybe most importantly, does your copy stop the original creator from being able to sell their work? It creates a flexible, but often pretty blurry line.
Fair use is the legal idea that literally made new technologies possible. When the VCR came out, the movie industry freaked out and sued. But in 1984, the Supreme Court said that recording a TV show to watch it later, what they called time shifting, was fair use. And later, the court said the same thing about copying a CD you already owned onto your shiny new MP3 player. That was space shifting. But then came the internet. Peer-to-peer networks and the ability to make perfect digital copies for free, this changed the game completely. That careful balance of copyright and fair use was totally thrown into chaos, and that's when the digital copyright wars really began. The entertainment industry's response was basically a 2-pronged attack. First, they fought with technology. They developed digital rights management, or DRM, to build digital locks into music and movies to stop you from copying them. And second, they fought in the courts, launching literally thousands of lawsuits against individuals, like that student we talked about earlier.
A massive turning point came in 2005 with the Grokster case at the Supreme Court. The court basically said, look, a VCR is one thing. It has plenty of legal uses. But services like Grokster were different. Their entire business model was designed to encourage people to break the law. They weren't just selling a tool, they were actively promoting copyright infringement, and that made them liable.
But here's the really crucial takeaway from all this. While the lawsuits and the tech battles made all the headlines, the war wasn't really won in the courtroom. It was won in the marketplace. Services like the iTunes Store and then later Spotify and Netflix finally gave people what they actually wanted all along: an easy, legal, and affordable way to get music and movies online. In the end, innovation, not litigation, was the real answer.
And that brings us right up to today, because these same battle lines are being drawn all over again, this time over generative AI. When an AI model trains on millions of copyrighted images to create something new, who owns it? Who should get paid? This fundamental tension between the rights of creators and the public's benefit from innovation, it's not over, not by a long shot. It's just moved to a new and honestly even more complicated battlefield. So where do you think that line should be drawn now?